Many first calls that I get from clients are because they've received a letter in the mail from the Massachusetts Commission Against Discrimination or Maine Human Rights Commission or EEOC telling them that an employee has filed a claim against them for discrimination. And there are two reactions that I see. One is to panic, and the other is to not take it particularly seriously. And the reason employers don't take it seriously when they don't is because they know that there's a legitimate reason for whatever action they took, and so they see the complaint as not having merit. That's a dangerous assumption to make because it's very expensive to defend these claims, even if they're not meritorious. And I think it also underestimates the narrative that an employee who feels wronged can tell to one of these agencies. So taking it seriously is important. I think the first questions that clients have when they get this are, can I do it myself? Can I respond to this myself? And if I don't, how much is it going to cost? And I would caution employers, especially ones without legal departments, against answering themselves without any input from counsel, because the things that are said in those submissions can have long-lasting and pretty dire consequences. It's easy for an employer to admit to violations of law unintentionally or to get facts wrong, and those will come back and bite them later. So a quick conversation with a lawyer, there are lots of ways lawyers can be involved. There is, taking the whole matter and being the face of it and being an advocate. There's also behind the scenes coaching and counseling on kind of do's and don'ts. And different approaches are appropriate or not appropriate depending on the stakes and the nature of the claim. And so I would just encourage any employer to pick up the phone and have a conversation with counsel about how best to respond to the complaint rather than ignore it and rather than simply charge ahead without counsel.